supposed to be representing citizens of Vermont in democracy.
Well, I knew what happened today. By the way, the other thing that happened today was that Green Mountain Power's attorney, Jeffrey Baird, sent a letter to the Attorney General's office this morning. It's posted on my attorney's website. And they are saying it will have nothing to do with this investigation. Around this energy business, these companies are coming in and they are making huge profits and leaving very little behind. We need far more transparency. We need transparent sound on making and how much they're leaving behind. We need to be a part of this energy revolution and not be pushed aside and be told that we can't have anything to do with it because we're, I don't know, stupid, dumb, cave people.
Collateral damage.
Collateral, yeah. So, I mean, Senator Rogers spoke very eloquently almost 3 weeks ago here at this podium, calling for a ban on industrial wind. Pick up the Wall Street Journal today. Robert Bryce has a column about the Vermont Energy Rebellion. I run a 501c3. I don't say or do anything to influence elections. There's another muscle that I operate under. So there are enough gags on our voices. Let's talk about what's going on. Let's get our legislators engaged in actually understanding what's happening. These are just surrogates for the many people who live around all these wind projects. We have one man in Reedsboro who was arrested, felony homeland terrorist charges, for complaining in the middle of the night about the Hoosac Wind Project over in Massachusetts. Now, he hired a lawyer, he spent a lot of money, he got off. He's not here. He's scared to death. This is our government coming down on people who are being victimized and further victimizing them. And boy, I know a little bit what that feels like, because I will say that this is no joke being under a criminal investigation by the Attorney General. I lived for 3 weeks with the threat of having a sheriff show up and seize my computers, with the threat of my phones being tapped, and people actually think my emails and phones are tapped right now. So, and then I got this specter that somehow I'm doing something that is violating something, but it's not really clear what it is. The other aspect of this, in case you're not aware of it, and why this is so highly unusual, is that there are only 5 cases in the history of Vermont. The last one was 1962. There are no rules promulgated to try one of these. It would be, in the first instance, a jury trial before the Vermont Supreme Court. Now, the jury trial piece I'm still not positive about, but you know, nobody knows how this would go, but you know, and there's no maximum penalty, and there is no appeal. And this could have hung out for years. This could have hung over me for years. So I'm enormously grateful to Attorney David Slay for taking my case, for helping me wade through what is a legal morass with being a 501c3, with can my organization pay my legal bills? So in that sense, I'm very relieved that it's going away, but I want to continue to move forward and get, if I never have to set foot in that public service board hearing room again, I will be very happy.
What's the answer to that question? Will your organization pay your legal bills?
I don't know. I still, nonprofit law is not an area that I've heard from a lot of criminal defense attorneys, but I've retained David personally. And so the fundraising that we're doing is to support VCE. To put this in perspective, VPIRG has a $22 million budget, and they have 16 people on staff. Vermonters for a Clean Environment has a $125,000 budget, and we have me full-time, and Elizabeth part-time, and John Brabant part-time. And we can do so much more with so much more money. So you feed the machine, and we will be doing more. And it's all good because we, the people, come together through Vermonters for a Clean Environment. We've been doing it on a lot of different topics. We do not win in court, but we certainly do win out in the real world.
Amen.
My question is, just to raise it in this perfect crowd, do we know why hydro has gone off the list? Did it go off at the same time as solar and wind came in? I lived in Swanton with a power plant that gave me cheap electricity.
Well, it's a
I
longer
wonder where it
question.
went.
Yeah, it's a longer
wonder
answer
where
than I
it
can
is.
give you, but it's not off the list. But it's, look, where's the money? Follow the money. The money is in developing solar and wind. It's enriching the 1%. All these projects, the way they're financed is through the investment tax credit, which then the solar projects, which require, let's say you have $1 million tax bill. Instead of paying the IRS, you can go ahead and invest in a solar project, and then you get a nice return on investment, more than 6%. Who's getting that? And so they're actually taking away the tax dollars from the IRS. They're investing in this stuff. And who's doing it? I don't know, Bank of America. Would love to see the list of all the people who've invested in all these community solar arrays.
So if they spent that money, or even half of that money, to retrofit hydro and bring it back in place, wouldn't that be a better way to spend some?
There are a lot of better ways to spend money than what we're doing now. Our energy policy is backwards, upside down. And you know, the other thing that's really, really disturbing is that I've been working on the wind issue for 6 years. 6 years ago, we had a bill drafted citing and setbacks for wind turbines. The chair of the House Natural Resources Committee wouldn't take it up. Oh, you people just want to ban it. Well, this year, Senator Rogers introduced a ban bill. I met with the Speaker of the House and Brian Dewey on December 22nd. Turns out it was the day after this complaint was received at the Attorney General's office. My sole purpose was to say, how are we going to move forward? And he said, we're not. I put these bills in front of him. I said, look, we don't care which conversation we have. We just want to have the conversation. I told we're not. Not a good year to do it. No. Election year. Get all tied up in elections. Well, you think it's gotten tied up in elections yet? You think people are going to be talking about how we can actually move energy projects forward in a way that benefits Vermonters and not the wealthy? So we have opportunities now that we didn't have before because of what's happened with this.
Annette, I'd like to make one point, and you raised it briefly, VPIRG, and the number of people from VPIRG in this building. On our first day in Senate Natural, there were 7 people sitting around the table around the side of the room. And out of those 7, 4 of them were from VPIRG. And now, VPIRG doesn't necessarily disclose where all their money comes from, but they are lobbying for energy developers in this building.
Yes,
I saw a letter from them this morning, which I think you forwarded to me, which had a fair amount of misinformation. One of the things we have to do a better job at is informing Vermonters that just because you see a panel or a windmill doesn't mean it's benefiting Vermont. If the RECs are being sold out of state and the money is going to the millionaire class and rich corporations, it's not benefiting Vermont.
That's right.
We need to make sure to impress that on all Vermonters.
You cannot look at a wind turbine, a big wind turbine, or a big solar array in Vermont and point to it and say that's renewable energy for Vermonters.
None of it.
None of it. Not a bit of it is renewable energy for Vermonters. So it's all selling the RECs out of state. And now there's efforts with these PERPA deals to try and actually, right now, at least the RECs are being sold and reducing their rates, but the PERPA deals would allow the RECs to be sold and benefit the developers. So we're going in a really wrong direction, and it's just getting worse, not better. I want to also mention that I said 6 years we've been shut out. Well, I talked to Jim and Sandy Wilbur the other day, and they started testifying in the House Natural Resources Committee in 2004, when Robert Dostis, who's now at GMP, was chair, and when Tony Klein was on the committee. They remember Tony Klein as being rude to them. Now think about this. 12 years, Vermonters have been coming into this building giving good testimony about the issues, and on the House side, we have been completely shut out. Corruption. We at least are being heard in the Senate now. And last year, I don't know if anybody saw what happened with the solar, some setbacks and things. That happened in the last 3 days of the session. It didn't come about because of committee hearings or anything. Last 3 days of the session.
It came about because of myself and Senator Campbell. He's the only person in leadership who has supported us at all. Yep. So a shout out for Senator Campbell.
the session made a difference. It stopped some really bad solar projects, because you know what Vermonters don't like? They don't like them too close to the road, and they don't like them in your face when you drive by, and they don't like them when they're bothering the neighbors and they're interfering with their view. How hard is this to be good neighbors? Yes.
Yeah, Annette, I was just wondering, when you said you met with the Speaker of the House, isn't his law firm the one that sent you the letters?
Yeah, I put the letters in front of him.
Okay,
He said, yeah, I saw you posted them on Digger.
so that looks like a law.
And then he pushed them back at me, and that was, I said, your law firm is actually, so I don't, it gets messy, yeah, not my fault. But I think I did the right thing. I saw where the pinch point was. I asked for a meeting. Brian Doobie was with me. I was very positive. I said we want to work on solutions. Now, I'd never met the man before, and it was very sort of discouraging to be told that, no, we're not doing anything this year. And when you see what happened in this room 3 weeks ago, we have to do something. We have to do it this year, and we have to fix this problem. We have to do way more than provide a public assistance officer at the Public Service Board, which is currently where the discussion is in our Senate. Wow. And so we have a long way to go in terms of actually coming up with real solutions. And it's very clear, land use does not belong at the Public Service Board. And by the way, they're so backlogged that I'm watching all kinds of cases. The fifth case in the complaint that was filed was the town filed their public comment on September 30th. If anybody wants to say the system is working, are you kidding? I don't know why developers would even want it. They're so backlogged. So this is the right time to make a change, and it's the right time for all of you to get to all of your legislators, and especially the ones in Chittenden County, who continue to support all renewables anywhere. And let's be good neighbors, and let's get along with each other, and let's stop fighting. Brooke.
Yes.
But I also want to just broaden the discussion just a bit.
Why don't you come up here? Brooke's an attorney. This is Brooke Dingelmeyer.
Hi, I'm with a Barrett firm, and I
Louder, please.
Can you speak in the mic?
It doesn't work.
Can I
switch positions with you?
Can you switch them? Sure. That represented the town of Newark in a Met Tower case, which are the test towers that are sited before an actual wind project. And we fought before the Public Service Board for the town to have a voice. And unfortunately, at the Public Service Board, the legal standard is that they only give due consideration to the position of the town. Due consideration is not a legal standard that is defined, and basically it's a misnomer because due consideration is meaningless. It means that the town's position can be completely disregarded. Now, I think you've seen some efforts on the part of developers wanting to win over municipalities and making statements like, if the host town is not going to be supportive of this, then we don't want to cite our project there. But I think that arises primarily because they don't want to fight on their hands. But the bottom line is that standard does not give our municipalities a voice. The other issue before the Public Service Board is, while there have been Act 250 criteria that have been imported into that process, there's a trump card. And that is it in the public interest? And in the Newark case, we tried to ask the Public Service Board and the hearing officer, and then on appeal to the board itself, to say, you have to figure out in this particular instance, is this a project that serves the public interest? And we were shut down on that, because if it's renewable, if it's wind or whatever, and they can couch it in terms of being renewable, then it is automatically in the public interest. That is then used as a trump card to disregard any adverse findings under the Act 250 criteria that are imported into that process. So that's very concerning, and while you may hear that municipalities are being invited into the process, or they may even be given automatic standing, what does that mean when their position is actually not considered and it carries no weight whatsoever in a decision? Now, there's one broader issue, and that has to do with the bill that's pending right now before the Senate committee. It's S-123. The private bar, and I consider myself part of the private bar because I represent, and I've represented small developers in the past, I've represented a large developer in the past, and I have represented a lot of neighbors and other groups. What I would like in the Act 250 process and the Public Service Board proceeding is fairness. And fairness requires a level playing field. The statue of Lady Justice is blindfolded because she's supposed to treat everyone the same who comes before her so that there's predictability to the process and nobody gets an advantage over anyone else. Right now in S-123, there is an effort to eliminate a de novo review by a court like the Environmental Court in permitting before A&R, such that A&R will become judge, jury, and executioner with regard to permitting. And if you don't get it right the first time, if you don't go in on that first level with your experts at great cost and present the evidence, then when you get before a law-trained judge, and our judges do a good job in the Environmental Court, they can only decide whether there was a pretty bad error below. They are not allowed to listen to new evidence. They are not allowed to consider information and weigh it. All they can say is, did the lower tribunal mess up? Abuse of discretion kind of standard. And this also is a problem in the Act 250 area because while our district commissions are great folks and they're citizens that are trying to consider, use their common sense and do the right things, often they are presented with highly technical information and legal standards that they perhaps have not been trained to or don't have the background or experience to apply the law to the facts in a particular case. It is essential that on-the-record review remain the standard in Act 250 proceedings and other permitting contexts. I mean, I'm sorry. Yeah, let me correct that. De novo. Thank you, Annette.
And I'm not a lawyer.
Oh, she's on tape now.
You are now.
It is essential that it is not on the record review, that we get a fair shake when we go before a law-trained judge. So when a client comes to me after they have dealt with that lower tribunal and they've said, yikes, we lost, we need your help now, that I can actually provide them benefit